Okay, welcome everybody, and thank you for joining us here today for our final segment of our annual Life Sciences Master's Program. The Master's, as many of you know, is a name that is associated with the speakers and the level of the speaker. And I'm honored to have a true master of our industry with us here today, Mr. Walt Copan, former Director of NIST, Undersecretary of Commerce, and currently Vice President in charge of Research and Innovation at the Colorado School of Mines. So Walt, thank you for being here.
Thanks so much, Gene, and thank you for the great work that IPWatchdog does on behalf of U.S. innovation and competitiveness.
Great. So you all are not only watching the last panel of our annual Life Sciences program, but this is also being contemporaneously recorded as the rest of the panels have been. But this will be on IPWatchdog Unleashed, our podcast, as well. So you're our first live studio audience for a podcast recording. So thanks for agreeing to that, Walt. I really appreciate it.
My pleasure.
Trying to get as much good quality information out about innovation and technology and IP as possible. And before we dive into the substantive IP conversation that I know that we talked about having, I just wanted to give you the floor to tell people what it is that you're doing and how you found your way to the Colorado School of Mines, and so let's kick off the conversation there. So take it away.
Great. Thanks so much, Gene, and thank you everybody for being part of these conversations. Incredibly important. So after my time as Undersecretary and NIST Director, perhaps some of you know that Andrei Iancu and I founded a program with the Center for Strategic and International Studies that we called Renewing American Innovation. The real focus to work with that public policy think tank on issues that affect national security through economic security, and so U.S. competitiveness being underpinned by intellectual property rights, the importance of standards, the importance of strategic investment by the nation in science and technology leadership, and also creating the kind of business environment for industries to gain return on investment and to create global reach as a result of their work, their investment in science, technology, and innovation. And I had many interesting opportunities, actually, Gene, after my time as NIST Director. Of course, I had known that agency over many years and had been the first leader of NIST that actually came from Colorado, which also happens to have one of the major NIST laboratories. And so thinking about staying here in Washington, having opportunities here and abroad, there was a lot of family reasons as well as personal connections through the National Institute of Standards and Technology, but also the National Renewable Energy Laboratory, where I had worked earlier in my career. And while I had been leading technology transfer and commercialization at NREL, which is also in Golden, Colorado, I developed a very strong relationship with Colorado School of Mines. The name is a fooler. It goes back 150 years, but it's one of the world's top engineering and science universities, and seen as a lead in quantum science and engineering. America's first quantum engineering program, for example, was established at that university. My predecessor at Mines had been the deputy director at DARPA, and with the current administration, she accepted the position as DARPA director. And so that vacancy led to a very interesting opportunity for me, not only to be back within 15 minutes of my family. 3 daughters live in Colorado, but also with this really wonderful gem for the United States in science and engineering. It's recently ranked in the top 3 engineering programs in the United States, together with Georgia Tech and MIT. And so it's a great place to continue engagement in aspects of intellectual property, technology commercialization, ecosystem building, and in particular, as the United States and other nations are focused on place-based innovation, it also gives me a great opportunity to work with fellow innovators, people who really care about IP and about venture investment, of taking technologies from the nation's research universities and research institutes to create impact for society and for the economy. And so it's a real pleasure to continue this type of work, being outside the federal government, but still having a voice with the federal government, and having the chance to work with our Colorado delegation, as well as the committees that have oversight for the things that I care deeply about, and that is seeing the United States continue to grow, to have a vibrant and reliable intellectual property system, and the ability to translate science and technology into value for the economy and for our communities around the nation.
Yeah, it's good to hear that things are going well for you. I will confess, I wanted to start there because when I saw that you went to the Colorado School of Mines, I thought, oh, there's probably some kind of personal connection there. I was shocked to learn that it's a top 3 engineering school. Shocked to also learn it's a top 40 public university in the U.S. So, there's obviously a lot going on there, and they've got a really good guy to move the institution forward. Because you were really one of us before you went to government, right? You were a on-the-ground IP professional, worked with a number of organizations and the universities, and really were, I would say, but I'd like you to comment, you were sort of like the tech transfer guy. Everybody knew you. You were so involved, and you came out of the industry and took over NIST and took it in a real positive direction, which we'll talk about next. But is that fair to characterize you as a lifelong tech transfer guy?
I won't say lifelong, but certainly a significant part of my career emphasis has been in this area of technology transfer and working at the interface between the public sector and the private sector to create value. It really started early in my career. While I had leadership roles in research and development at Lubrizol Corporation, which is a very research-intensive corporation headquartered in Cleveland, Ohio, and with strong relationships with my alma mater, Case Western Reserve. And while I was at that company, I saw the direction that we were taking the company. And how important it was to bring partnerships together, partnerships with academic institutions and research organizations, our federal laboratory system. And I saw in many cases the friction between those interfaces, between public sector and research organizations and the corporate side, with, in some cases, cultural mismatches, in some cases, legislative authorities that were necessary to actually make it easier for the private sector entity like mine to interact with universities and research institutes. And so I started really in my earlier days saying, how do we make this better? I was involved with the U.S. National Academies of Science, Engineering, and Medicine with a program that was called the University Industry Demonstration Partnership, UIDP, that since has split off as an independent organization, but still engaged with the national academies. And so working on best practices, but also I saw on the side that it was really important to deal with the policy underpinnings, because the structural aspects, the cultural aspects of dealing with government entities and academic entities required a lot of work, required a lot of engagement and relationship and trust building. And so from that beginning, really in tech transfer and managing an intellectual property portfolio and a venture capital portfolio that I ran for the company, these were intended to transform an industry, transform a company, and bring new entrepreneurial technologies in to drive change, to drive access to new markets. And so I saw firsthand the essential aspects of intellectual property, because we would not invest in an entity that did not have clear intellectual property rights. We would not be able to see a return on capital employed as a result of those types of engagements. Sure, there would be great ideas, but it would simply be a relationship to harvest ideas, but not necessarily commercialize those.
Yeah. Many years ago, Jay Walker, the founder of Priceline.com, told me, "You simply can't invest in what you don't own." And it's a truism that just seems so self-evident.
Yeah.
And particularly when you're coming with somebody like from Jay. I mean, he's prolific inventor, 900 to 1,000 patents, multiple companies he's founded, and one of the largest internet companies still in existence, right? And you would think when somebody like him says it, it would carry a little bit more gravitas, but that message just doesn't seem to get through and resonate. So it's interesting to hear you, and I'm sure you've heard the stories about how the Cleveland Clinic is no longer following certain paths of innovation because they can't protect it, so they can't start up companies.
Right.
I've heard stories about St. Jude, making the same types of choice, and those are not isolated. That goes all throughout research development, but those are specific. I mean, for me, if I had a child who had cancer, I would want St. Jude innovating as much in every area that they possibly could. And the Cleveland Clinic is one of our great medical institutions. It's royalty from other countries fly to the Cleveland to go to the Cleveland Clinic, and they're not, and they innovate. Don't get me wrong, but there's certain paths that have been stopped from them pursuing because they can't protect it, and they can't stand up startups, and they can't get investment to do what needs to be done. Can you speak to that reality, like this, particularly the startup, the university startup, that we all romanticize so much because that's where so many great ideas come from?
Yeah, I saw that firsthand, actually, while at Lubrizol, because an area that we were taking the company is into the life sciences, and in particular into biopharma. And these were intended to be transformational innovations that we would support, that we would engage with. And so the first investments that we did were in Genentech. So we were the initial investors in Genentech. Cetus, the home of PCR, and really the first Nobel Prize to a private sector entity for that invention. Was what our company was investing in, and really seeing the opportunity of life sciences also to transform chemistry and materials, renewables, and feedstocks for the materials that we needed for fuels, for lubricants, and ultimately for the digital economy, and seeing the importance of intellectual property. Even a non-exclusive license that kicked off Genentech, the Cohen-Boyer patents that were so important in those early days of the biotech industry, enabled then a company like Genentech to build its own unique portfolio, unique connectedness, but through trustworthy intellectual property rights and through licensing strategies that were really thoughtful. And so the chance to work with the leading universities on their strategies to understand what they were hoping to accomplish in the public interest through creating platform opportunities for intellectual property advancement through non-exclusive, but then selected field of use types of licensing opportunities. And as a company, we would not have taken any of those investments forward unless there was a clear intellectual property pathway. The ambiguity that we're seeing currently in intellectual property rights, and previous speakers here have just talked about the challenges of of clarity of interpretation of IP rights in certain key areas that are important to the life sciences, that are important to the future of the biopharmaceutical industry. Create some real challenges. It's certainly challenges for counsel to even advise inventors on what is actually protectable or not, and then ultimately looking at legislative underpinnings that are so important for startup formation through the Bayh-Dole Act and the Stevenson-Wydler Act around federal agency inventions, have also, I think, created some concern for the investment community, certainly in the pharmaceutical space, as we're looking at the ramifications of the framework for margin rights, for example, that has been issued by the administration that came out of my former agency at NIST, which I believe were well-intentioned, but provided actually greater uncertainty for the legal profession to be able to understand and interpret and to guide the whole process of invention, leverage, and the process of startup formation, which is so essential to job creation and to economic vitality in this United States.
Mm-hmm. So let's just take a step back there, because the margin rights are a very important, very hot issue. Probably most of the people in this room understand what's going on there, but just the real quick recap is that the federal government has the right to come in and take patent rights under some limited scenarios. It's my understanding that margin rights have never actually been exercised.
Correct.
And they have increasingly over the last at least decade, probably longer, been attempted to be used to come in to take patent rights where some agency or some group that's advocating that an agency step in thinks that the product that is covered by the patent is too expensive. And over again, NIH has responded to this repeatedly and said correctly that the Bayh-Dole Act does not give anyone any opportunity to come in and march in and take rights based on price. This is not a price control. And that's been the historic understanding. I had the opportunity to interview Senator Bayh before he passed on the 30th anniversary of Bayh-Dole, and he laid it out what they were trying to do, and price controlling was not what was on the table.
Right.
And now your former agency, NIST, has precisely come out with a set of rules, I guess, or proposed rules at this point, where they will specifically consider price with marching. Is that a fair characterization? Did I get anything wrong?
I think it's a fair summary, Gene. The nuance that I would provide is, number one, the framework that NIST issued around appropriate scenarios for march-in rights. It is simply a framework. It's not a rule. So it does not fall into a regulatory framework, although NIST does have regulatory authority delegated to NIST.
Okay, so that's an important distinction. So let's peel the layers of that onion, because I guess I didn't realize that.
Yeah.
So, well, first off, let's start. Is the march-in proposal or framework at NIST, that is still not effective yet, correct?
That is correct. It was a proposed document. It was issued as a document for comment. It was issued under NIST's regulatory authority for the Bayh-Dole Act, but in itself did not go through the process of promulgating regulation. So it did not go through an interagency process or appropriate interagency review, and it was not issued as a regulation. It was issued as a guidance framework to enable practitioners to understand when would it be appropriate to even consider a march-in action for a federal science and technology funding agency to look at a change in intellectual property rights distribution that, generally speaking, under the Bayh-Dole Act, could render, let's say, an exclusive license to a non-exclusive license provision. So it would not fully take away intellectual property rights from a licensee, from a startup company, for example, but it would change the dynamic of the use of those intellectual property rights and could also enable a specific transfer of intellectual property rights from that initial entity to someone else who is seen as capable of commercializing it in the public interest. Mm-hmm. So it's not a regulation per se. It is under the regulatory authority, which is part of the confusion.
Yeah.
And this is one of the reasons why when the framework draft document came out in a request for information, a lot of head scratching out there saying, well, what do we do with this, right? And I'm a lawyer. I'm trying to interpret this, but I've been given all these narratives that actually lead me to less clarity rather than the intent, which I know is the case, just seeking greater clarity. But the issue that I had worked on while I was director at NIST, I led an initiative called Return on Investment. It was intended to be a national conversation about the importance of technology transfer and commercialization through our innovation process, looking at all those aspects of regulation and policy and legislative underpinnings that we might, as a nation, wish to modernize in the current competitive dynamic with the ascendancy of China and other nations really building their own innovation capacity. What does the United States need to do so that we can win the race, that we can continue to innovate with high productivity, and to remove acknowledged barriers to innovation and competitiveness by reducing what I call the friction between the public sector and private sector, and provide greater clarity also in rule of law, that the United States would be the trustworthy place even for foreign direct investment in technology companies because of the importance of the intellectual property positioning that company had access to. So yeah, it's an unfortunate state of affairs. I'm optimistic for the future that with the many comments that knowledgeable organizations submitted in response to the request for information, and also the current interest of the U.S. Congress to act on legislative modernization for the Stevenson-Wydler Act, the companion legislation to the Bayh-Dole Act, that we have some hope for the future. But boy, this is a tough time in the intellectual property business with a lack of clarity that we've seen, and also with some of the guidance and some of the rulings that we've seen on the judiciary side that has created challenges for the intellectual property protections that we need in this part of the 21st century with convergence of technologies, the use of AI as a tool to enable human productivity, right? So it's intended to enable and to support the human invention capacity at the same time.
Yeah. So can you just give us a quick overview on, you mentioned Stevenson-Wydler a couple times, and for people who aren't steeped in the Bayh-Dole area, I think it's easy to mistakenly believe that the public universities, private universities, and federal labs all are under Bayh-Dole and under the same regulatory regime and under the same statutory regime, but that's not the case, right?
It is indeed not the case. And so Bayh-Dole applies to government contractors, and in particular a university, a corporation, a small company, for example, a federally funded research and development center, FFRDC, a federal laboratory that's operated by a contractor on behalf of the federal government. For example, the majority of the Department of Energy's national laboratories are operated by contractors. But the National Institutes of Health is a federal agency and operates under the Stevenson-Wydler Act. Its licensees and its academic partners operate under the Bayh-Dole Act. And so the idea of this legislative reform, Gene, was looking to harmonize Bayh-Dole with Stevenson-Wydler to bring them into close connectivity as well, but also to remove some of the existing barriers that were embedded in the Stevenson-Wydler Act that makes it more difficult for organizations like the National Institutes of Health to directly be engaged in technology commercialization. And the other factor here, because many of the researchers directly working at NIH are federal employees, there are federal conflict of interest requirements that they need to abide by. And what that has done is it's actually led to some great research talent being forced to leave the federal government employment because they were so passionate about seeing the technologies that they were working on commercialized and made accessible to the public. So these pieces of legislation both came out in 1980 within a couple of months of one another. But the Stevenson-Wydler Act has some built-in legislative barriers that have made it that much more difficult to work directly with federal agencies, with federal employees who are trying to engage in technology transfer, commercialization, and partnerships with the industry.
Yeah, and I remember very vividly coming to a program that you put on at with NIST. I think it was at the International Peace Museum,
the Institute of Peace.
Institute of Peace
in
D.C.
Washington,
yeah. And Secretary Wilbur Ross at the time was there, and he showed up, and he just very matter-of-factly, and this is what you get when we have business people go into government and say, he said, I look at the numbers of innovations and the amount of jobs that have been created and the amount of products and treatments and really wonderful things that have gone into the public domain through Bayh-Dole, and I see that as a success. And then I look at the numbers that have gone in under from agencies and those who are governed by the Stevenson-Wydler Act, and he said something to the effect that I just want to know, well, why hasn't anybody done anything about this disparity before? Because if it's working for Bayh-Dole, why shouldn't it also be working, and to the same extent for the federal agencies? And it's not, and there was a real attempt to try and get something done, and it didn't wind up happening. But do you think that there will be some appetite to try and, I mean, we always are going to have to fight the Bayh-Dole battles because people forever want to undo it, which I don't get. But do you think that there is a hope at the end of the tunnel here? The light at the end of the tunnel is not a train for federal agencies.
I do. I'm optimistic. I think that the dynamic that we currently see in national security and competitiveness, I mentioned the ascendancy of China, China's intellectual property system, and China's investment in technologies that are supported by standard essential patents as well, that there is a growing awareness that the United States needs to be in a position to compete as effectively as we can and to remove legislative and policy barriers to that.
Can I just stop you right there for a second? Because where does that appreciation exist? And the reason I phrase it like that is it has been a shock for me that members of Congress particularly haven't clued in to what I'll call here now, it's probably not totally accurate, the China threat. Yeah. And it's not a threat like, I don't think that they're going to declare war on us, we're going to declare war on them. But I do think in a world where companies are competing against each other to innovate, we not only need to be looking at the Western world, we need to be looking at the Eastern world. And China is putting a lot of time, money, and energy into becoming dominant across the board in multiple different areas. Why that hasn't resonated in the power structure in D.C. is confusing to me, because it does seem, and maybe this gives you an opportunity to also tell us a little bit about CSIS, which you're very involved in as well. The think tank world seems to get it. Many in the private sector seem to get it, but it's been frustratingly slow to permeate the government.
Yeah. I think this is an ongoing education opportunity. Obviously, in a democracy, we have change on a regular basis. New leadership, new staff, new leadership in the key agencies, new leaders of the cabinet agencies as well, each bringing their own unique backgrounds, each building their own staff. And so, whereas a country like China is able to maintain greater momentum, constancy of purpose without these sort of periodic changes that we have in a democratic society with all the benefits that we enjoy of democracy, means that that we should continue to educate, to advocate, and to engage with policymakers, with stakeholder communities, industry, the academic community, innovation ecosystems, startups, and another sort of small subset of the population are the former federal employees who actually had to leave federal government in order to engage in technology transfer and innovation and commercialization activities. So the other aspect that we've seen is a misuse of legislative authorities. We talk about the Bayh-Dole Act. It's a misuse of the law to try to solve a drug price problem that's perceived by the public and that's perceived by lawmakers. And so there's this aspect that we see in government of promises made, promises kept. And so if you're voted in on a platform of we're going to solve the affordability crisis of American healthcare, and I'm going to use every tool at my disposal to do that, regardless of the consequences, we have an education challenge ahead of us if legislative and policy tools are being misapplied. And so I think that is one of the areas that, together with many partners that I'm focused on, together with Andrei Iancu at the Center for Strategic and International Studies, to hold convenings. It's a nonprofit organization, so we're not in a position to advocate for legislation, but we are able to inform and we are able to convene stakeholders who really understand these types of issues, bringing in leaders from industry, bringing in entrepreneurs, and investors who get it. And so I think although we have these regular challenges in a democracy, the differences in our innovation system challenges that were pointed out by Secretary Ross at the time, that we are we're damaging the United States and our ability to continue to be a global economic superpower through these legislative impediments and through these policy restrictions. The other aspect that we've seen that is a longer-term aspect, and having worked in the federal government and with government contractors, as an entrepreneur, as an investor, in large companies, small companies, nonprofits, and now in academia, I've kind of got this perspective that basically says that the United States, at this unique juncture, really needs to bring forward those in Congress who understand intellectual property rights. And thankfully, Coons and Tillis have been such stalwarts, and their great staff in understanding these types of issues. And there are others as well whose districts, both on the House and on the Senate side, who see the importance of leveraging the research at their institutions and the federal institutions within their region. And so I'm pleased that there is great recognition now that's growing within the House Science Committee, within the Senate Commerce Committee, that have oversight for a number of these agencies. Certainly within the Judiciary Committee, we have a bit of a mixed bag. Within the Help Committee, thankfully we have senators such as Colorado Senator Hickenlooper, who is really working with his staff and really understanding these types of issues. So I am the eternal optimist. I believe in this country, and I believe that through this sometimes very messy and sometimes agonizingly slow process, we'll get there. And sometimes America will only respond in a crisis.
That was what I was just going to ask you. Do we need a crisis? I mean, because that's what got us out of what I will call the doldrums, which President Carter called the malaise.
Right.
For the fear that the Japanese were going to dominate the high-tech sector is what really caused so much of the impetus of forming the Federal Circuit, of creating Bayh-Dole, probably also of the Supreme Court getting those 2 eligibility cases correct in the early 1980s. It was a moment in time where it seemed like across the spectrum in America, everyone understood the importance. We have to get this right.
Yep.
Otherwise, we're going to forfeit the future. And I don't see that awareness. I mean, I see, and if you're not familiar with CSIS, they're, and correct me if you disagree, Walt, but largely have, up until recently, been thought of as more of a national security think tank, a defense think tank. Yep. But they see this these IP issues as national security issues, and are doing, you and Andre and others that are working with you are doing yeoman's work. But do we need, and I hope we don't have it in some respect, but do we need a crisis to get the attention to fix things?
A crisis focuses the mind. And we've seen many crises already. One of the areas where Colorado School of Mines is a world leader is in critical materials, and so the future of the mining sector and innovation. And the majority of critical materials innovation and production currently is flowing through China. And we have seen China halt the export of certain key materials that are important for the electronics industry, that are important for the energy sector, and important to the defense sector. Those are shots across the bow. They have been temporary. But in many ways, I think that the power that China is able to wield, the importance of intellectual property licensing as we're looking at intellectual property commerce and standard essential patents, the primary cash flow is between the United States and China because of the production capacity and the manufacturing innovation that China has built. I participate very much with the National Academies of Science, Engineering, and Medicine, and the president there, Marcia McNutt, held a State of the Science briefing a few months back, again in preparation in some ways for the elections, a new administration, thinking about the State of the Union, and in this case, the state of the science, and pointed out the growth of China and other nations in the technologies that matter, and there have been a number of studies. Bloomberg has put out over the years an innovation index, and how does the United States rank versus other key players, and we've seen there that the innovation gap is narrowing between key players, including the United States and China. So I do firmly believe that a crisis is coming. We face many grand challenges globally, and many of the activities in science and technology and engineering that are supported by the U.S. government are taking place in government-owned and government-operated installations. And to former Secretary Ross's point, if we are unable to leverage the result of that science and technology to create a return for the American people, and thereby reducing America's competitiveness and national security, we need to drive change. And so that's something that I know Andre and I are continuing to echo as an important message, but doing so in a way that is bringing together coalitions and partnerships. The C4IP organization, looking at the future of intellectual property and having the opportunity to directly engage with Congress in different kinds of ways, I think it's going to be a very, very helpful dialogue, not to be a fearmonger, but to be a realist. And to look at the threats that we face as a nation, but also to look at the unlocked opportunities that we still have as Americans to drive greater value and bring more of the great technologies from federal investment to the marketplace, and to continue to remove barriers for the private sector to create the greatest return on investment from their work.
Yeah, so much of this is frustrating to me as an engineer because I fundamentally don't like taking a system, throwing it away, and starting over. Because in the current system that you have, you know where the problems are, and rarely are the problems so overwhelming that you need to just say, okay, let's just erase that. Everybody forget what we've been doing. Let's chart a whole new course. Because when you do that, you get all kinds of things come up that you couldn't have possibly imagined. Like we were talking this morning about how clinical trial data and information that is required to be given to the government and posted to the government web page is now being used to demonstrate that is prior art, against applicants later on. And that is a relic of, not maybe a relic isn't the right word, but a feature, unintended feature of the AIA and first to invent versus first to file, where we live in the first to file world now. So I am not in favor of throwing things away, but it feels to me like across the board in the IP area, and I keep using the word forfeiting our lead, the U.S. lead, I feel like what we've done is say, this was working, this was great. Rather than tweaking to fix the problem scenarios around the edges, what we did is said, let's just erase it all and start over from the ground up. And it's not working. In my opinion, it's not working. What do you see? I mean, you have a very unique perspective, having been from the government, been in the private sector for so many years, and being in the public and private institution in the academy. What is your perspective on what's really going on from a big picture? Are we just throwing the baby out with the bathwater?
I think there are parties that are unwittingly attempting to do that by misapplying legislation, by really twisting policy. The foundations are strong. The foundations go back to the beginning of the nation and our Constitution, and the importance of clear intellectual property rights, the enablement of entrepreneurship by the little guy, rather than the support of the crown for the organizations that were favored to receive these protections. Going back to those first principles and building on the great legislative tools that we have, continuing to support the integrity of the Bayh-Dole Act, modernizing Stevenson-Wydler to enable greater good to be accomplished from that. It's not the time to throw the baby out with the bathwater. It's really time to double down on those things that have worked well for America and to continue to improve them while maintaining their integrity.
That's great. That's probably a great place to stop here. It's very uplifting and it makes me feel better. We heard a lot of horror stories over the last couple of days here, but your optimism is infectious. and I hope you are right, and I think we all do. We all hope that you are right, and frankly, I hope we get another director at NIST like you, who really, for the first time in my career, charted a different path for NIST. And I think that's really because you are one of us. You understand the industry inside and out, and the incentives, and what the researchers need, what the universities need, what the licensing companies need. And so, and I know you're happy in Colorado, and I won't put you on the spot with the election coming up to see whether or not you'd be interested, but I do hope we get somebody like you in that role again, and I really appreciate you being here today. Thank you so much, Walt.
Thank you so much, Gene, and thank you all for being part of this important conversation. The future of healthcare is underpinned by clear intellectual property rights, and by the licensing, by the manufacturing agreements, by the partnerships that are supported by the rule of law. And we've seen very, very unfortunate proposals. We've seen the TRIPS waiver proposed, and thankfully the follow-on to that has languished. But there's a lack of appreciation for the importance of these intellectual property provisions that go to the foundation of our nation for the future of this industry. And it's an industry that's under attack. It's an industry that's facing increased competition, including increased competition from China. This is part of the Made in China 2025 roadmap to see China grow and to be able to dominate in the biotech and the biopharma sector, amongst so many others. So thank you all for the work that you do, for the awareness that you are building within your respective organizations, for the advocacy that you and colleagues are providing to continue to inform intelligent policy formulation in this nation, and to continue to lead by example. And I'm committed, regardless of the outcome of the election, to see the best leaders in this nation to be best informed and best supported with the information that they need to guide policy for the future.
Great. Thank you so much, Walt. That was fantastic.